This video is a review for the upcoming midterm exam, and what we're going to do is we're going to look at parts of last year's midterm exam. I don't have a clean copy of last year's midterm exam on a memory stick here because I did it on my tower computer at Capilano University, and I have no intentions of risking COVID-19 to go in and get a clean copy. What I will do, though, is I will use one of last year's students' exams. This young lady got 94 out of 100, so she did very well. And what I'll do is I will white out her answers and her name, and I will send it to you as a scanned-in document. You can print it off and practice doing the exam. I highly recommend you do that before you look at this video. You will get a better mark on the midterm this year if you do that. Then I'm going to go through parts of it, and then what I'll do is I'll actually send you a copy of her exam with her name whited out, and because she got most of the answers correct. So it's same as last year, same format. The only difference being last year was a closed book exam, and it was only 1 hour and 20 minutes. So this term, because there's no way we can have a closed book exam, we will have an open book exam. It will be 3 hours long, and I will expect more detailed answers. Rather than just listing, I'll probably ask you to list and explain. 3 parts, Part A, Part B, and Part C. Part A is 15 terms, 18 definitions. You match the best definition to the term. And again, I don't want you to memorize verbatim the definitions. What I want you to do, though, is learn the definitions so that you can recognize the right definition and put in the letter in the blanks, in the appropriate blanks. So I'm not going to put 2 definitions that are so close you're looking at the grammatical construction to try to figure out which is the right one. That's sort of multiple choice type questions, and I don't like those. So you could probably work your way through if you had enough time and say, okay, what does that mean? Oh, that's probably the answer. The difficulty you have is you only have 3 hours. You think, oh, 3 hours, plenty of time. If you plan to come in to the exam with the textbook and say, okay, let's see, proxy, okay, index, proxy, okay, that's page 42, okay, a proxy of this, okay, then go through the list, proxy, find it, proxy, oh, okay, and put in the letter for proxy. You do that for 15 terms, and you'll finish that part, and you won't have very much time at all to do the remainder of the exam, which is exactly what happened on my BADM 107 exam during the spring term, which was our first online crack at this. Okay, same format, basically the same terms to a large extent, because the first part of BADM 307 is a review of the BADM 107 material. And the students spent an hour and a half on Part A, and then they found that they had to work through Part B, and then they got to Part C, which is 40 marks, and they had no time to do it. And so they were getting 8 out of 40, 12 out of 40, and there's no way that you're going to get a good mark in the exam unless you prepare in advance. My recommendation is that you do use the Quizlet, or you use index cards. You put terms on one side, vicarious liability, for example. You flip it over. On the other side, you say an employer is responsible for paying for the torts of their employees committed during the course of employment. Not only do you do that in preparation for studying, but you should be doing that from the very first day and carrying those cards around with you and answering them. You wondered where I went, right? Or you use this thing, right? And you do Quizlet, and you go, and everybody thinks, oh, look at that cool person. He's texting. He must have a lot of friends, and you're looking cool, and you're actually studying, and nobody knows it. I think you do that, And then you'll be able to go through part A and say, I know this one, don't know that one, leave it blank for a minute, know this one, know this one, know this one, don't know that one, leave it blank. And then when you're finished, you'll have 2 or 3 blanks out of 15. Quickly use the text, find the answers, bingo, you're on to the next part. You've already got 30 marks out of 100 and plenty of time to do the rest of the exam. Okay? All right. Then you get into part B, and question 1 in part B, you do not know what's coming at you. The reason for that is it has to be worth 10 marks, and it has to be a substantial amount of material, so it'll either be on torts, or it'll be on discharge of contracts, or it'll be on contractual matters, and then what's the other? Constitutional matters, I think. Okay, some large amount of information. And so you won't know which one, but you can actually prepare those chunks in advance. And then questions 2 through 9, 8 questions, you choose 4. Okay, last year's exam was only an hour and 20 minutes, so you had question 1 you had to do, and you had to do questions 2 questions of 2 through 9. But because you have more time, you'll have to do 4 questions of 2 through 9. But on those, I'm looking at 5 marks each, and so I'm as lazy as any other instructor. I'm not going to go out and spend 6 hours creating the perfect Part B exam question. What I'm going to do is look for something that has 5 terms, or 5 items, and use that. Okay, like the advantages of a corporation over partnerships and sole proprietorships. Well, it's unlimited or limited liability, continued existence. Shareholders do not owe a duty of care, good faith. There is tax advantages, and there's another one which I can't remember right now, but that's good enough for now to make my point. Okay. Then you get into Part C, and my recommendation here is that, as with the tort practice problem, you list the tort issues on one side of the page, and on the other side of the page you list the principles. Except on the exam it'll be torts, it'll be company matters, it'll be contract matters, and sort of steps in a court action, things like that from Chapter 1. So it'll be a mixture, but you just list the issues on one side, list the principles on the other. As you're flying through, you get down there and you go, false imprisonment. Oh, I can't remember the principle. Leave it blank, go on. Get all the issues down in as many principles as you can, and then you'll maximize the marks on Part C, and then you go back because you have extra time, and you get into the textbook or get into your notes, and you pick out the principles for the ones that you've missed. Okay, and there'll be a number of batteries and assaults and defenses to those, and if you sweat bullets over one, you're going to waste time. So just get them down as quickly as possible. The other thing is, if you think you see an issue, put it down. Okay. If it isn't an issue, I'm not going to take marks off. But if you run out of time, or if you say, "Oh, I don't know is that an issue? That might be an issue. I don't know. Oh well, I'll leave it blank." And it turns out it is an issue. I cannot give you marks for it. So if you think it's an issue, put it down. Let's see. Okay. Part A, I'm not going to go through those answers. What I will do is I will give you the practice exam. You can try them yourself, and then I will send through the answer key from this young lady, and you can check your work. Part B, though, question 1, I do want to go through, and so here goes. Ben Counter sat across the conference table from his legal counsel, Will Argue and May I Sue, of the firm of Bell, Argue, and Harangue. Counter asked for a meeting so that the lawyer could explain the appeal that Peak Performance Pontoons, Inc. was about to commence. A former customer, Natalia Brezhnev, had been injured while whitewater skiing and had sued Peak Performance Pontoons. and Benton Counter in the court. On the advice of legal counsel, Peak Performance Pontoons and Counter had elected, in the Bajanajistanian court, a foreign court, there was a typo on the exam. Counter had elected not to respond. Why? Well, because if you respond, then you're consenting to the jurisdiction and you're fighting a court case in another country on the other side of the world using civil law and their legal system, which you know nothing about. And it could be fraught with all sorts of legal pitfalls, and there could also be corruption and unethical activities there. And so you don't know that, right? So he said, do not respond to the jurisdiction of that foreign court. As expected, a default judgment had been taken against them because they didn't show. However, what came as a surprise was that Madam Justice Grumble of the BC Supreme Court allowed the default judgment to be registered against the defendants and Counter, who then became referred to as. Okay, we went through that in the lectures. If you win in a small claims court, you become the judgment creditor because you're owed money by a defendant, and if you lose, then you are the judgment debtor because you owe the money in accordance with the judgment. There appeared to be numerous something or others and something or others which allowed Peak Performance on Pontoons Inc. and Counter to appeal her judgment and seek an order of the BC Court of Appeal that the judgment be overturned, dismissed, whatever. What's missing, or what were the numerous things? Numerous errors at law and numerous errors on the facts. Okay. How do we know this? Well, in class we were doing an exercise, which we will not be doing this term. We actually did a moot court where some people were appellants' lawyers and some people were respondents' lawyers. And so this fact pattern related to that exercise. But you don't have to worry about that. Whatever's in yours will make sense to you. Benton Counter was prepared to pay the necessary legal fees, but wanted to be apprised of the process involved. Argue explained that a document called a Notice of Motion, had to be filed within 60 days of the date of Madam Justice's judgment. She put Notice of Motion. That was incorrect. It has to be a Notice of Appeal. Okay. Once that document was filed, Peak Performance Pontoons and Benton Counter were referred to as, gosh, this is a toughie, the appellants, and the other parties are referred to as the respondents. Then she would, and then they're required to file a notice of response to the appeal. After that, Peak Performance Pontoons needed to file a factum. That's a document that lists all your arguments and outlining the arguments and facts. Okay. Then Brezhnev has to file a similar document. The parties to the appeal could file a joint factum containing legal precedents and the other necessary documents. You don't have to worry about this too much because that is really related to that particular class. Okay, I'm just going to make sure that you have the answers. The final document necessary for the appeal process is a record. Okay, I can't remember what it's called. It just says that you're prepared to proceed, right? Counter said, it sounds complicated. What if one of the parties misses a deadline for filing the documents? May I sue? Responded, the party must file a request for an extension of filing and bring on what's called an interlocutory application in order to get the court's permission to file after the deadline. Okay, at the hearing of the appeal, Peak Performance Pontoons will argue that the most significant both the lower courts was that the plaintiff. The most significant argument from the lower court was that the plaintiff, Brezhnev, did not prove negligence. Okay, that's the argument. In order to sue someone for negligence, you have to do what? This you should know. You You have to prove that the defendant owed you a duty of care, that the defendant breached that duty of care, and the defendant's actions caused your damage. Well, I believe that's one of the many mistakes Madam Justice Grumble made. A waiver of liability is a something type of defense to negligence. What's a waiver of liability? Just think it through. A waiver of liability is a contract, either part of the purchase price for taking a trip, you're doing some sort of adventure business, or it is a separate document signed under seal so that this consideration isn't necessary. But it is a contract, and therefore it's a contractual defense. A well-drafted waiver will also allow the defense of blank, which is a common law defense which stands for the proposition that the injured party cannot recover because he or she was aware of the dangers and voluntarily accepted the risk. Valenti non fit injuria. Common law defense. He who accepts the risk shall bear the loss. There are also a couple of other defenses that reduce potential liability. In this particular situation, it was contributory negligence. You first put up your defenses and try to say there is no negligence, but if the court does hold that there is negligence, then perhaps you can reduce your exposure to liability by saying, well, Natalia Brezhnev knew she shouldn't do this, knew she was tired, but went ahead anyway, so she contributed to her own injuries. It says contributory negligence because it could be argued that Brezhnev refused to stop skiing even when it was suggested that she do so. So she is responsible for a portion of her own injuries. Second, if both PPP Inc. and Rattlesnake River Rafting, because there were two defendants, are held to be negligence, then the loss gets proportioned between the two of them, and that's under the Negligence Act. Okay, so remember there are 6 defenses to negligence. And these defenses don't say that it wasn't negligence that the defendant did. The defendant has to be held to be negligent, and then these defenses kick in. Yes, Peak Performance Pontoons was negligent, but there was a waiver of liability signed. There was Valenti non-fit injuria. There was the Negligent Act should apply. Brezhnev was contributory negligent, and then the other two are, one of them is extirpi causa non oritur actio, which says if you do an illegal act, then you don't get to sue someone to recover for an injury. And then the last one is the Good Samaritan Act, okay, which means you were negligent, but you were trying to help someone rescue them, and therefore you're absolved of any negligence. Those some of those don't apply to this situation, but that's the 6, and that would make a good 5-mark question for Part B. Okay, so that is the problem in question number 1, and I will be drafting another problem. I think, what did I say? It could relate to the makeup of the Constitution. It could be, what you do to use your lawyer's time effectively. It could be the discharge of contracts, or it could be some more tortious matters. All right. Oh, and question number 2 is, in fact, deals with this whole idea of discharge of contracts, and I want to run through that. Contractual law, because that's the new material that was in the first part of the course. Contractual obligations may come to an end and be discharged in 4 ways. What are the 4? By performance, by agreement, by frustration, by operation of law. Okay, and then it goes on to say, assume that Nikita Brezhnev and Natalia Brezhnev both bought a set of Peak Performance Pontoons beginner skis during their trip to Canada. Now they want their money back. However, Peak Performance Pontoons refused, and the Brezhnevs sued for breach of contract. The contract would be considered to be discharged by performance because Peak Performance Pontoons sold them the skis and Natalia paid for them. The contract has in effect been fulfilled. All right. Okay, she did not answer some of these, and so you won't have the answer guide. I will probably scribble in the answers. And then if you have any questions, you will be able to ask me about them. But I'm not just going to read them over the video. Otherwise, you won't bother learning them. Okay, but what I want to do is I want to go through Part C very carefully. I do have a Part C answer guide, which I will be forwarding out to you. And so I'm just going to put you on hold for a second while I grab that guide. Okay, I have my skydiving marking guide, so let's get at it. You are required to answer this question with the benefit of 20/20 hindsight. List the legal issues and applicable legal principles. Ignore criminal matters. Then indicate one retained risk, one shifted risk, and one reduced risk measure the business took or should have taken. All right, Daphne Dithers and Hilda Huff get into this skydive for dollars thing, and that's the first 3 paragraphs before we get into any issues. I'm not going to read it because you should have it. Then we get into the paragraph. Daphne and Hilda were certain that the venture would make money because it was a thinly disguised copy of a popular and successful business called Scuba Dive for Dollars, TM, where the weighted bags of money are thrown into water. Okay, they're using a name that's very similar, and so obviously the issue here is intellectual property issue, trademark infringement, or passing off. Because there's a TM there, we don't know whether it's actually a registered trademark or not. Probably not, so it would be passing off. But you don't know that, so put both down. There's no regulations in Canada as to how you mark your products for a trademark or patents, that sort of thing. They have it in the United States, but not here. Well, TM generally means not registered. R in a circle means registered. Okay, next paragraph. Eventually, Daphne and Hilda hoped that their skydiving competition would be popular enough to warrant its own television program. Woo! So they planned to videotape the jumps. Thus, all the entrants would not only have to sign a waiver of liability, absolving Skydive for dollars of any liability for injury or death, but would also have to sign a publicity release allowing their pictures to be used on TV without compensation. That's pursuant to the Privacy Act, Section 3, which is a BC statute. Other provinces don't necessarily have the same statute, but it says in there that the use of someone's picture without their permission is an invasion of privacy. Okay, so I guess you could put down standard form contract there and mention the waivers of liability. Probably wouldn't get any marks for it because it's not really an issue at that point. An issue is a problem or potential problem. Daphne suggested to Hilda that if the sport was to look good enough for TV, new fancy chutes and helmets would be needed. She showed her a catalog from the Skydive But Don't Die Parachutes, Inc. Good name, eh? Hilda agreed, and so Daphne emailed an order for 5 parachutes at $1,380 per chute. This was a very good price, but the next day she got an email back from Skydive But Don't Die Parachutes, Inc., which said that the prices had gone up, and if Daphne wanted the chutes, she would have to pay $550 more per chute. Daphne sent back a scathing email saying she had accepted the offer as set out in the catalog, and if they didn't send the chutes to her at the agreed upon price, she would sue them. However, she received another email from Skydive But Don't Die Parachutes, Inc., suggesting that perhaps Daphne had made too many jumps without a helmet. Outraged, Daphne tried to send another email to Skydive But Don't Die, saying that they were not honest in their business dealings, but in her anger she hit the wrong button on her computer and sent the email to all their customers and suppliers as well. Okay, obviously here the price tag on the catalog is an invitation to treat or an invitation to do business. It is not an offer. That means that she was making the offer, they didn't accept, so they're entitled to increase the price. Most businesses don't because they want your patronage, but they don't have to. Now she hits the wrong button, out goes this broadcast email, and she has committed a defamation. What type? Libel. And then you give the definition of the definition of defamation, and then you get marks. Okay, so you get one for saying it's defamation, and you get one for saying it's libel, and then you get one for the definition. So my suggestion is that you list the issues on one side of the page, okay, and on the other you put the principles. That way, if you put down invitation to do business, you get the 1 mark. Prices are not offers; they're mere invitations to do business. You get 2 marks. Well, then you have this defamation, right? And you put defamation, and you put libel, and then you go, oh, I can't remember the definition. Oh, I can't remember the definition. Leave it blank. Okay, come back to it later. You know, when you're working through, you'll go, oh, wait, I know it, and then you can go back and fill it in. But if you put the issues on one side and the principles on the other, then you're less likely to forget. If you do it in paragraph format, I can mark it. That's no problem. But you're liable to say, oh, defamation, it's libel, bingo, and then you go on to the next issue and you forget to put in the principle. Okay, let's see. All right. Hilda took over the task of getting the new chutes and soon had ordered some from another business. The new business opened with a flurry of activity. One possible contestant, Mr. Wunsler, decided against the idea, and as he was leaving the store, he noticed a bin of used helmets. When he asked about the helmets, Hilda said that the helmets were the old ones that the business was no longer going to use. But because they were used, they were going to be given away rather than trying to sell them. Mr. Wunsler said he would take them, and Hilda said, sure, fine, whatever. And when Wunsler came back into the store to get the helmets, Hilda had said she just remembered that her partner's nephew had said he was interested in them. So she was not going to give them to him after all. Mr. Wunsler said that she had offered the helmets to him and he had accepted, so they had a deal. If she did not give her the helmets, she would sue. Okay, well, obviously, sure, you can take the helmets. That's a gratuitous promise. Why? Because Wunsler is getting consideration. He's getting the helmets. But what's Hilda getting? Nothing. Okay? So it's a gratuitous promise, a promise made in the absence of a bargain, and there is no contract, so he could sue, but he wouldn't be successful. She told him, let's see, where I would Oh, Hilda told him to get out, but Mr. Wunsler said he was not going until she gave him the helmets. Always a calm person, Hilda said, then I'll skydive you out the door on your nose, and she advanced towards Wunsler. Wunsler responded saying, I know karate, ha ha, oh, don't die. And with a blood-curdling scream, he tried to kick Hilda. But apparently he did not know as much about karate as he thought, because Hilda caught him by the foot and propelled him into a nearby stockroom and closed the door and locked it. Okay, so obviously she says, get out, and he won't go, so he becomes a trespasser. A trespasser is somebody that comes onto your property wrongfully or once on your property and you tell them to leave, stays. Hilda advances at him. That's assault, apprehension of imminent, harmful, or distasteful contact. He says, I know karate. This is... back up. Hilda has defense against assault, and that is she can use reasonable force to expel a trespasser. Then Wunsler comes at her with his karate. Again, that's assault with the attempted kick. But he has a defense, and that is that Hilda was coming at him, and so he was allowed to defend himself. Don't worry about who's right and who's wrong. Just get the issues and the principles down. So Hilda then grabs him by the foot and propels him out the door, or into the closet. Immediately grabbing the foot means it's a battery. Okay. Now she has a defense, obviously. I mean, somebody's going to kick you, you grab their foot. But it is a battery, grabbing his foot and propelling Wunsler into the closet. She does have a defense, obviously, self-defense. Use of no more force than is reasonably necessary. She puts him in the closet and locks the door. This is false imprisonment. Okay, so you get 1 mark for saying false imprisonment, intentional unlawful confinement. 3 elements to false imprisonment. Well, without the confinement, there's no issue, right? So the 2 key ones are intentional and unlawful. It was definitely intentional. Unlawful, well, it was part of her defense, I guess, that she had to do it because he was a trespasser and wouldn't leave. So you put down false imprisonment, then you say she has a defense, and the defense is that a crime has been committed. Okay, the defense to false imprisonment for the police is that they have a reasonable belief that a crime has been committed. For other people, though, the defense is a 2-part. Number 1 is you have to a crime has to have been committed. Okay, and then you have to have a reasonable belief that that person committed the crime. So a crime had been committed, trespass. Okay, trespass is also a crime, so she can make the defense. Okay, Wensler screamed some insults at Hilda for a while, but eventually calmed down, and Hilda agreed to let him out if he would leave peacefully. But this was really not Hilda's day. As he walked towards the door, he inadvertently tripped on some parachute cords which Daphne had on the floor as she tried to untangle them. Wensler injured his foot and his knee and had to be taken to a nearby hospital. Okay, they are occupiers of premises, so this becomes occupier's liability. You can put down negligence, you'll get 3 marks, but if you put down occupier's liability, you can technically get 4 marks. Occupier's liability, what is he? Well, he's a trespasser, okay? What do you have to do in order to not injure a trespasser? Not injure them through careless disregard, okay? And then the Occupier's Liability Act now sets out these factors, okay? So there's your 4 marks. However, not too long later, all these preparatory problems were dealt with, and Dithers and Huff were ready to have the games begin. To eliminate the problems with receivables, all contestants were required to pay the entry fee by certified check. The first 2 teams of contestants, Wanda and Hank, and Harold, an 18-year-old, and 18-year-old Willard, were aboard the plane preparing to jump when Daphne said, "You don't jump until you sign this." He handed out the publicity releases and waiver forms. Once they had done that, once that was done, the bags of money were tossed out the door, followed by the 4 contestants in rapid succession, and one of the business's employees, Thornton Funk, with his video camera. Excited to be doing the filming, Thornton forgot to attach a safety line from the camera to his belt. He lost the grip on it and watched it helplessly as it fell to the ground. It narrowly missed some onlookers, but went through the roof of a BMW car, causing thousands of dollars in damages. Fortunately, he had a spare camera and was soon recording the action. Okay. Now, we talked about the waiver earlier, and I said you could put it down if you wanted. You would get the marks there or here, didn't matter, but you don't get them in both places. Waiver is a standard form contract, and then the issue is what was done at the time the contract came into existence to bring the onerous terms to the attention of the contracting party. Absolutely nothing. Okay, they paid by certified check in order to jump, and then later they the business people tried to get them to sign the waivers. Well, obviously, the contract is already complete, and nothing was done at the time the contract was entered into to bring the owner's terms and condition of the waiver to their attention, so it's not going to be enforceable. Well, wait a minute, they signed the waiver later, but isn't that part and parcel of the consideration for coming into the contract? No, that's past consideration, amounting to no consideration at all to bind the parties to the waivers. The waivers would have to be signed under seal. And I've just read a really interesting case. A lot of businesses photocopy the waiver form with a red seal on there, and so they've got the waiver form, but it comes out with a black circle there. And it seems as though in some jurisdictions, and it seems to be that way in British Columbia, that black circle is not considered sufficient to be a seal. Rather, it suggests that that's where the seal should be placed. Okay, Let's see. Now, thunk drops the camera, crashes through the car, negligence. He owed a duty of care, breached the duty of care, and caused the damages. He's liable because he gets sued for negligence. But the business, Skydive for Dollars, hopefully Inc., is vicariously liable for the torts of the employees committed during the course of employment. Okay. Let's see. Wanda and Willard proved to not only be proficient divers but overly competitive individuals. They each grabbed 3 bags of money. However, to do so, they both delayed opening their chutes until the automatic control did it for them. Consequently, they both hit the ground a little too hard and sustained injuries. Is the business responsible for this? No, they're not. Probably called an unavoidable accident, or they caused their own injuries. Contributory negligence, although there have to be, no, it's not contributory negligence. To be contributory negligence, somebody else has to be negligent. The business isn't negligent. Those things are a safety device, and they opened properly, but you hit the ground hard. Okay. Let's see, where are we? The other 2 contestants, Hank and Harold, were equally competitive and simultaneously went after one of the bags of money. It turned into a tug-of-war with both of them refusing to let go. Down they plummeted, tumbling towards what appeared to be certain death with Thunk filming each gyration. Finally, the emergency control on the parachute automatically deployed their chutes, causing the chutes to intertwine with each other. But the audience breathed a collective sigh of relief as Hank and Harold finally began to drift apart. However, that short delay was enough to cause them both to hit the ground too hard, and both required hospitalization. I think the business would be negligent because this is something that was foreseeable. Foreseeability is an element, and then they would also be contributory negligent. Okay. Let's see. But the audience decided to come in. Yeah. From his hospital bed, Willard called his bank and arranged to put a stop payment order on the check. Daphne and Hilda were angry and so sued him in small claims court. They also received a notice of claim from the owner of the damaged car. Hilda said, I'll put it in my pile of paperwork and we'll take care of it after the first 4 weeks of the primary games are concluded. Then I'll have time to deal with it. Okay, so let's see. The waiver is unenforceable against Willard because he is a minor. Okay. The Age of Majority Act says you're a minor until you're 19 years of age. Now, he signed it, but it doesn't matter because the Infants Act says that parents cannot, or neither the child nor the parents can waive their rights. Okay. Delaying taking care of the notice of claim is steps in a court action. A default judgment will be taken against them. You only have 2 weeks to file a defense. All right. The business was a notice of claim from Willard's mother, who was suing because they used her son's picture. As they shipped the notice off to the lawyer, Daphne asked, why is she suing? We didn't use her picture and her son signed the waiver. All right, we already dealt with the fact that the child isn't bound by the waiver, and this using the picture is misappropriation of personality. The unauthorized use of a picture or likeness of another, and you could put down the Privacy Act in British Columbia and then get an extra point. Why is she suing? Well, because the child is under the age of, actually he's 18. So she's suing as his guardian ad litem, I guess, because he's injured or something. You'd have to be under the age of 18, so that was a mistake in my problem. Okay, This was all too much for Hilda. As she was driving home from work that night, she felt dizzy and had a pain in her chest. She quickly pulled over to the side of the road and thought, great, am I having a heart attack, or is it just the 5 burritos I had for lunch? Maybe I should think about getting my estate in order. The pain subsided, and off she went home. Okay, estate matters. You want to have a will, a power of attorney for business, a power of attorney for personal matters. You want to have a representation agreement, and you want to have a comfort letter. Now, the risk management, there's all sorts of things you could put here. The things that they did to reduce the risk, well, there's the chute automatic openers. They could ask to make sure that they're certified expert jumpers. If they have a partnership, then they can have a partnership contract. Let's see, move the spectators. Okay. Let's see, file a trademark application on the we're not skydive for dollars. Why? Well, it would protect the name, but it was also, if you filed it, it would be refused, and then you'd go, oh, okay, well, gosh, I guess somebody, skydive or scuba dive for dollars, I guess we're too close. Okay, and then they would name their business something else. Shifting risk, well, the waivers, okay, they could incorporate the company to shift the risk, they could get insurance to shift the risk, and they could have safety talks. Okay, there's nothing in there about safety talks. Just before somebody gets involved in a really adventure, tourism, dangerous activity, the promoters should give a safety talk outlining all those things you could do to keep yourself safe, but also the dangers of doing it. And then they would have the valenti non fit injuria defense, which is he who accepts the risk shall bear the loss. Eliminate the risks? Well, how about a business plan? I mean, if they'd gone through a business plan, they probably would have thought, this is too dangerous. Okay, and the other thing they could do really easily would be have the jump separately. I mean, do they have to jump and go after the bags all at the same time? I mean, it's exciting seeing all those people and everything, but wouldn't it be just as easy to throw out a bag of money and let one person jump, and if he gets it, great, they get points. The next person jumps, misses, so they don't get points. Or, and then you just continue the jumps until everybody, either gets bags or misses bags, and then you know who won. The retain the risk. Well, you look at all these problems and you say, okay, we're going to incorporate, we're going to get insurance, we're going to make sure they sign waivers. So we've done everything we possibly can to shift the risk, but let's just retain the risk and do the business. All right, so that is the part C, and again, I suggest that in preparation for this exam, I hope that you've done that problem in advance, because that will make a difference to your grade. If you didn't, it's too late now, but what you might want to do is then put this video aside, go through the problem, try it one more time, and then see how you do. All right, that's all in this video. Thank you very much.